The judge did not raise her voice. She didn't need to. She leaned forward slightly, adjusted her glasses, and held the document still in her hands longer than protocol required. The clerk stopped typing. The low hum of the ventilation system felt suddenly louder than it had a second before. "Counsel," the judge said without looking up, "can you explain why this financial authorization references transactions dated 3 days after it was supposedly signed?" No one answered immediately. Bradley Fenwick rose halfway from his seat and then settled back down again, as if his body had acted before his thoughts caught up. My mother shifted beside him, her heels scraping faintly against the wooden floor. It was the kind of sound people make when they realize they're being watched. I kept my hands folded in my lap and my eyes forward. I didn't know exactly what the judge had noticed, but I had a sense that something small, something procedural, wasn't lining up the way it was supposed to. The clerk stamped the exhibit into the record at 8:47 a.m. I noticed because the clerk hesitated before pressing the stamp, then glanced up at the judge before completing the motion. This hearing had been scheduled as routine. That was the word Bradley used when he filed it. Routine guardianship review, routine concern, routine protection. Bradley cleared his throat and stood fully this time, smoothing the front of his suit with practiced confidence. "Your Honor," he said, "the petitioner is a concerned parent. She believes her daughter lacks the mental capacity to responsibly manage inherited assets." My mother nodded, solemn and controlled. She had chosen her seat deliberately, close enough to the aisle for visibility, far enough from me to avoid eye contact. She wanted the court to see her before it saw me. When she stood, the pearls at her neck caught the overhead light. I recognized them immediately. My grandmother wore them on Sundays, sitting at the kitchen table with her checkbook open, a calculator beside her coffee mug, the television muted so she could focus. My mother clasped her hands. "I've been worried about her for years," she said. "She struggles emotionally, poor judgment, long-standing instability. She doesn't see it herself." Bradley handed the judge a thin stack of papers. "Counsel has provided documentation, including prior counseling records and a recent evaluation confirming my daughter is not fit to oversee financial matters, especially not an estate valued at over $160,000. The number landed cleanly, not emphasized, not explained, just placed. The judge glanced down, then up at me, not with sympathy, but with assessment. I didn't react. That seemed to unsettle my mother more than any argument could have. "My daughter isolates herself," my mother added. "She's secretive, defensive. She's always believed she knows better than professionals." Bradley nodded along. "The petitioner is requesting guardianship solely to protect the assets from mismanagement." He didn't say theft. He didn't say misuse, just mismanagement. The judge looked at me. "Miss," she said, "do you wish to respond?" I stood. "No, Your Honor." Nothing more. A bench scraped softly behind me as someone adjusted their position. The clerk paused mid-entry, fingers hovering over the keyboard before resuming. My mother exhaled through her nose, a controlled breath that sounded almost like relief. She believed silence meant weakness. The judge nodded once and returned to the file. She turned a page, then another. Her fingers stopped. "Counsel," she said, eyes still on the document, "this power of attorney was notarized on March 11th. "Yes, Your Honor." "And the withdrawals listed here begin on March 14th. "Yes." She tapped the paper lightly. "Then why does this authorization reference a compliance review dated March 17th, signed by a branch manager who was not employed at that location until April?" Bradley blinked. Once, then again. I'd need to verify." The judge raised her hand. She didn't interrupt him sharply. She simply ended the sentence. "I will verify," she said. "For now, I have questions." She turned to my mother. "Mrs. she said, the judge, "how many times did you visit the bank with your mother in the last year?" My mother hesitated. Less than a second. "I don't recall exactly," she said. "I was helping her." The judge made a note. "And how many times did you access her account directly?" "I was authorized." The judge looked up then. "Authorization," she said, "is not the same as frequency." She closed the file halfway. "We will continue, but not as scheduled." She looked at the clerk. Mark this exhibit as provisional. The clerk paused, then nodded, adjusting the entry before confirming it aloud. Exhibit marked provisional. The judge glanced at the calendar on her desk. This matter will require additional review. We'll reconvene after verification. She wrote a date on the margin of the file, not today's. Then she looked at me again, not searching, measuring. I sat back down. My mother stared straight ahead now, her lips pressed together, her performance finished. The room felt smaller, more precise. This was no longer routine. The system had begun slowing itself down, paper by paper. The hearing did not end cleanly. It recessed. That distinction mattered. The clerk stamped the file provisional and slid it into a gray folder instead of the blue one I had seen earlier. The judge set a follow-up date without discussion. April 22. No explanation, no ruling. Just a pause that felt deliberate. By the time we stepped into the hallway, my mother had already regained her composure. She spoke quietly to her attorney, one hand resting on his sleeve, her voice low enough that it sounded cooperative instead of aggressive. People passed us without looking. The humiliation did not escalate in public. It became administrative. That afternoon, my debit card stopped working. The notification came at 3:18 p.m., a generic message. Account access temporarily limited. No reason listed. When I called the bank, I was placed on hold for 11 minutes before a compliance officer explained that a guardianship petition automatically triggered restrictions once it entered the court docket. It did not matter that nothing had been decided. The filing itself was enough. 2 hours later, my medical portal locked. The login page refreshed and asked me to verify my identity through an external provider I had never used. When I finally accessed my records, I saw the same evaluation my mother had referenced in court, dated March 14, uploaded again under a new case label. The report was unchanged. The context was not. The next morning, a certified letter arrived. It was dated 3 days earlier. Inside was a notice from the court administrator explaining that any financial transactions over $2,000 would require secondary authorization pending review. The wording was neutral. The effect was not. Rent was due in 6 days. My savings account showed $14,620. I could see the money. I could not move it. By Friday, a second letter arrived. This one referenced an older document, a therapy intake form from 11 years ago. I recognized the clinic name immediately. I also noticed something else. The provider's signature at the bottom did not include a license number. I did not comment on it. I placed the letter in a folder and marked the envelope with the postmark date. 48 hours later, a third notice appeared in my email. It informed me that my employer had been contacted to confirm my work status for assessment purposes. The request was polite. It included dates: start date, June 3, last performance review, January 9. The tone suggested routine verification. My supervisor called me at 4:42 p.m. to ask if I was all right. I told her I was aware of the inquiry. That was true. What I did not say was that the same law firm had requested similar confirmations from 2 previous employers listed on my resume. One of them had closed in 2019, the other had merged in 2021. The requests were spaced exactly 7 days apart. None of this required my participation. That was the part people misunderstand about this process. You do not need to respond for pressure to build. You just need to exist inside it. My mother did not contact me directly. Instead, I received updates through systems, a voicemail from a bank representative confirming that a joint account had been flagged, an email from a clinic billing department asking for clarification on recent disclosures, a notice from the courthouse indicating that additional medical records had been requested under supplemental authority. Each message arrived during business hours. Each one used careful language. Together, they formed a pattern. On Monday, I went to the branch in person. The branch manager was polite. She spoke in measured sentences and avoided eye contact while explaining that she could not override the restriction without a court directive. When I asked which documents had triggered the freeze, she listed them from her screen. 3 items, all dated within a 5-day window, all submitted by the same attorney's office. One of the documents referenced an account balance of $167,400. That number did not match my records. I did not correct her. I asked for a printed activity log instead. She hesitated, then printed 6 pages. The timestamps ran from 8:12 a.m. to 2:03 p.m. across 4 separate dates. I folded them carefully and placed them in my bag. On Tuesday, my mother filed an amended statement. It reframed the issue as concern. It removed the word unfit and replaced it with temporarily impaired. It cited the same therapy record again, this time attaching a cover letter signed by a consultant whose name appeared nowhere else in the file. The formatting was inconsistent. The margins were narrower. The page numbers restarted halfway through. Still, no one challenged it. That is how this kind of abuse works. It does not rely on lies. It relies on volume. By Friday, my credit card issuer reduced my limit from $9,500 to $1,200. The notice cited risk reassessment. The assessment referenced the same court case number. At no point was I asked to respond. At no point was I interviewed. I watched the system behave as if a conclusion had already been reached. That night, I laid everything out on my dining table. Not to solve it, just to see it. 3 letters, 2 emails, 1 voicemail transcript, 6 bank pages, 4 medical documents, 1 amended filing. The dates clustered tightly. March 11, March 14, March 17, March 19. The same names repeated. The same language appeared in different formats. The pressure was not random. It was timed. The next notice arrived Thursday morning. It informed me that an independent evaluator would be assigned if cooperation could not be confirmed. The phrase was vague. The implication was not. I placed the notice on top of the others and noted the timestamp at the bottom of the page, 9:06 a.m. I did not respond. I did not call my mother. I did not explain myself to anyone. I waited, because by then, something else had become clear. Every restriction, every inquiry, every letter depended on the same small set of documents, and those documents were being reused. The same evaluation, the same account summary, the same signatures. They were traveling through different systems without changing. That was not concern, that was replication. On Friday afternoon, I received one final update. The court administrator emailed to confirm that additional records had been accepted into the file and would be reviewed in due course. The email included an attachment list, 12 items. I recognized 9 of them. The other 3 were new. One of them referenced a bank visit that had not occurred. The date was March 17. The time was listed at 2:12 a.m. I saved the file. I closed my laptop, and for the first time since the hearing, I stopped feeling the weight of the pressure itself and started noticing its shape. Because systems can be loud, but they are not creative, and once they repeat themselves, they become readable. Nothing changed on the surface after the hearing. No calls, no apologies, no corrections. 3 days later, the same envelope arrived, stamped March 17, postmarked 2 days after the judge had paused the proceedings. Inside were documents I already knew by memory: the medical evaluation, the guardianship petition, the financial summaries. Only the order had changed. Pages were rearranged, attachments were missing, references pointed backward instead of forward. I placed them on the table without reacting. By then, I had already started keeping everything, not emotionally, procedurally. I created a folder structure that mirrored the case file, not because I trusted it, but because I wanted to see where it contradicted itself. Every document was scanned twice, once as received, once after comparison. I didn't rename files descriptively. I named them by timestamp. Silence helps patterns surface. I logged dates first: March 11, March 14, March 17, then times: 8:47 a.m., 2:12 a.m., 4:09 p.m. Some documents claimed urgency, others claimed delay. None of them acknowledged each other. I didn't label anything suspicious. I didn't highlight a single line. I aligned them. On a spreadsheet, each row was one document. Each column was a variable. Signature date, notarization date, referenced location. Account number, professional name. If I had missed even one of them, none of it would have lined up. By the fourth document, the pattern stopped being subtle. 7 bank visits, 19 days. 7 withdrawals followed within 48 hours of those visits. $12,480, $7,300, $9,950, $18,000. No two amounts repeat. Everyone stayed just below internal review thresholds. That wasn't caution, that was familiarity. I didn't react. I pulled the medical file next. The evaluation presented in court was dated March 14. The provider license number appeared in the footer. I copied it exactly and checked the public registry. Expired 14 months earlier. No reinstatement, no temporary approval. The signature format matched another evaluation dated 11 years prior. Same initials, same structure, different ink density. I placed the 2 pages side by side and stepped back. When people fabricate, they usually rush conclusions. What they don't rush is formatting because they assume no one will look there. I didn't make a conclusion. I made a note. Then I checked the notarization. The guardianship petition listed a branch location that had closed the previous summer. The notary stamp named a branch manager whose employment record showed a start date in April, 3 weeks after the notarization date. I checked again, then once more. The timeline didn't bend. It broke cleanly. Still, outwardly, nothing shifted. At home, conversation stayed normal. Too normal. My mother spoke with calm confidence everywhere else. She referred to the case as already handled. She described delays as technicalities. When she mentioned finances, she used rounded numbers, estimates, instead of figures. She spoke in summaries. I worked in originals. Every document assumed I had already lost control of my money, my work, my name. That assumption appeared everywhere. In the phrasing, in the urgency, in the way consent was implied instead of recorded. I requested bank activity logs next. Not aggressively, not formally. I asked for a compliance review copy, citing discrepancies between mailed summaries and in-branch transactions. The request triggered nothing visible. No alerts, no callbacks. 6 days later, a sealed envelope arrived. 43 pages. Page 17, device access history. Page 22, branch override approvals. Page 31, repeated authorization notes entered under the same employee ID. That ID appeared 5 times across 3 locations. I added another column. By the end of the week, the spreadsheet had 6 tabs: dates, amounts, signatures, locations, personnel, and one reserved only for inconsistencies that could not legally coexist. The more I added, the quieter everything became. No new documents arrived. No one asked questions. Confidence thickened around me like insulation. I didn't confront anyone. I didn't warn anyone. I booked 1 consultation and brought only copies. No originals, no explanations. The attorney read without speaking. 12 minutes passed. She didn't skim. She didn't underline. She didn't ask for context. When she finally looked up, she asked 1 question. Who else has seen this? No one. That was enough. After that, I stopped organizing chronologically and started organizing causally. Which document justified which restriction? Which evaluation triggered which withdrawal? Which letter arrived just early enough to satisfy internal deadlines? It wasn't emotional. It was mechanical. The same professional names repeated across unrelated paperwork. Identical formatting errors appeared on documents allegedly produced months apart. One account summary referenced a balance that existed for only 36 hours. That balance matched a transfer time stamped at 2:12 a.m. No system allows that accidentally. I didn't print conclusions. I printed exhibits. Everything stayed calm. Everything stayed quiet. Everyone else remained confident. They assumed I was still reacting. I wasn't. I was waiting. Because when the final document slid into place, there was only one explanation left. That document could not legally exist, and yet it was carrying the entire case. The hearing resumed without ceremony. No announcement beyond the clerk calling the case number again. No reminder of stakes. No acknowledgement of the gallery. The room settled not because it was instructed to, but because everyone had learned what silence now meant. The judge did not look up immediately. She reviewed the updated exhibit index instead. One document had been moved, two had been relabeled, a third had been separated entirely, its tab no longer aligned with the rest. She tapped the edge of that separated folder once, not sharply, not to draw attention, just enough to mark that it existed. "Counsel," she said, still reading, "you may proceed." My attorney stood, but she didn't approach the microphone yet. She placed a single document on the lectern first, aligning it carefully, squaring the corners as if orientation mattered more than explanation. "This exhibit," she said, finally, "was introduced by the opposing party as foundational." She paused. "It is now listed as provisional." The word did not echo, but the clerk's typing stopped. The judge lifted her eyes. "Why," she asked, "is a document relied upon for financial liability now marked provisional?" Opposing counsel stood immediately. His chair moved louder than necessary. He began speaking before he was fully upright, explaining process first, then intent, then institutional norms. His words moved faster than the sequence of events they were meant to justify. The judge raised one finger. "Stop," she said. The room froze into stillness. "I am not asking why you believe this document should stand," she said. "I am asking why it exists in this form at all." She turned a single page. "This document references a branch location that was no longer operational on the date it claims execution," she said. "It bears a managerial authorization attributed to an individual whose employment records place them elsewhere, and it appears, unaltered, in 3 separate filings." She looked directly at opposing counsel. "That is not corroboration," she said. "That is duplication." No one reacted. The gallery stayed silent, not from discipline, but from discomfort. Someone adjusted their posture. A bench creaked faintly, then went still again. The judge continued. "Ms., she said, addressing the opposing party's mother for the first time, "you have represented this document as independently verified." The woman stood smoothly. She adjusted her jacket, nodded once, and spoke in polished sentences. She referenced procedure, standard practice, and reliance on institutional safeguards. She did not mention creation. The judge allowed her to finish. Then she turned to the clerk. "Retrieve the metadata log attached to Exhibit 17B, she said. The clerk hesitated, not from confusion, but from confirmation. Then she complied. The display behind the bench updated. No explanation followed. The judge spoke again. "This metadata indicates that the document was uploaded 3 times, she said, from the same terminal, using the same credentials within a 14-minute window." She paused, letting the timestamps remain visible. "That is not independent verification," she said. "That is repetition." She looked across the room. "Does anyone dispute this?" No one did. My attorney spoke again. One sentence. "There is no original source, only replication." The judge leaned back slightly, her expression unchanged. "Then the foundation collapses," she said. She turned to the clerk. "Strike Exhibits 12, 14, and 17 from active consideration," she said. "Reclassify them as non-originative. Remove all derivative references." The clerk repeated each instruction quietly as she executed them. Each keystroke landed with finality. The judge did not look at me. She didn't need to. "Without those exhibits," she said, "the financial claim no longer satisfies evidentiary threshold." She closed the file in front of her, then opened a different one. "This court does not proceed on assumption. It proceeds on provenance." She reached for the scheduling sheet beside her. "This matter is continued for review of potential procedural irregularities." The date she selected was close enough to matter, far enough to investigate. The clerk stamped the continuation. Opposing counsel sat back down slowly. He did not speak again. The woman beside him remained standing for a moment longer than necessary, then sat without comment. The judge made one final notation, and the record will reflect that responsibility for submission accuracy rests solely with the submitting party. She closed the restricted folder. The sound was soft, decisive. Nothing else was said. The courtroom did not empty immediately. After the judge finished speaking, no one stood up. No one rushed toward the door. The bailiff waited, hands folded, watching the bench instead of the room. The silence lasted longer than any argument earlier that morning. My mother sat very still. The petition in front of her had been closed, not rejected loudly, not dismissed with commentary, simply closed. The clerk stamped the final page, aligned it carefully with the others, and slid it into a sealed folder. The timestamp printed automatically. It was 11:26 a.m. The judge did not look at me when she spoke again. She addressed the court. The medical evaluation dated March 14th was excluded in full. The banking activity referenced within it occurred over a 19-day period that began 5 weeks later. The document had relied on account movements totaling $47,850 that did not exist at the time the evaluation was signed. The notary license attached to the document had expired 14 months before the signature date. None of that was explained. It was read, slowly. My attorney did not stand. She did not ask permission to add anything. She simply placed one more folder on the table, opened it to the first page, and waited. The judge noticed it. She asked one question. When did the financial authority first flag the account? My attorney answered with a date, July 2. The bank compliance officer, seated 2 rows behind us, confirmed it without being prompted. 7 withdrawals, 7 branch visits, total amount $62,230, all initiated under a power request that had never been formally approved. That was the first moment my mother turned toward me, not in anger, not in fear, in calculation. The judge spoke again, this time directly to her. You testified that your daughter was incapable of managing her affairs. My mother nodded once. The judge did not raise her voice. Then why were the transactions structured to avoid automated alerts? The question was not accusatory. It was logistical. My mother did not answer. The judge did not wait. She turned to the clerk and issued instructions. The guardianship petition was denied. The financial restriction request was terminated effective immediately. Account access was to be restored by end of day. Copies of the transcript, exhibits, and bank records were to be forwarded to the appropriate investigative unit for review of document alteration and unauthorized financial control. There was no gasp in the room, only movement. The bank officer stood. The court reporter adjusted her headset. The clerk began organizing files in a new order. My mother remained seated. When the hearing adjourned, the bailiff opened the side door. Not for me, for the compliance officer and the investigator who had quietly entered during the last exchange. They spoke to my mother using polite language. They asked for her identification. They asked if she had transportation arranged. No one used the word arrest. No one needed to. Outside the courtroom, my attorney handed me a single sheet of paper. It was not celebratory. It was not framed as victory. It was a procedural confirmation of restored control, stamped and signed, listing account numbers, dates, and conditions. The number at the bottom was precise, $167,400, verified balance, access reinstated. She told me the rest would take time. Reviews always did. 12 weeks, possibly longer. There would be letters, requests, interviews. She said my role was finished unless contacted. I thanked her. She nodded once and left. I did not stay to watch my mother speak to anyone else. I did not wait for explanations. I did not look for apologies. I walked out. 3 days later, a certified letter arrived confirming the denial. 2 weeks after that, another letter confirmed the opening of a formal review into the documentation submitted on my behalf. A month later, I received notice that restitution proceedings were being evaluated separately. None of the letters mentioned emotion. They mentioned dates, page counts, amounts. That was enough. People later asked how it felt to win. I did not answer that question. What I learned was simpler. Silence is not weakness when it is structured. Preparation is not visible when it is done correctly. Systems do not respond to outrage. They respond to inconsistencies. My mother believed confidence was control. She believed speaking first meant deciding the outcome. She believed history could be reused if it sounded official enough. She did not notice the numbers. I did. The system noticed them too, and once it did not need me anymore.